Tenancy law in Ontario primarily governed by the Residential Tenancies Act 2006 (RTA). This act establishes the framework for regulation residential rent and various aspects of the landlord and the tenant relationship in Ontario. RTA applies to the most residential tenancy properties in the province. RTA applies, and however there are some specific exemptions, such as the unit where the tenant share the washroom or kitchen facilities with the owner, as well as certain type of accommodation like hotels, prisons, and education institutions. Under specific conditions, RTA does not apply. In case the tenant share the washroom and kitchen and he has some grievances with the landlord, he cannot go to the Landlord Tenant Board because he is sharing kitchen and washroom. Notably, in cases of conflict, the Ontario Human Rights Code, in case there is a conflict, then the Human Rights Code takes the priority over RTA, and Human Rights Code is prevailed. The key aspect of Residential Tenancy Act, tenancy agreement. It's very important. The RTA mandate that use of standard lease form from the most new tenancy agreement enter into or after 30th April 2018. The landlord has to give the agreement to the tenant. Failure by the landlord to use this form gives the tenant certain rights, such as demanding the signed copy and potentially withholding the rent or terminating the property earlier. Provisions in tenancy agreement that are inconsistent with RTA, and these conditions, regulations are wide, such as clauses prohibiting pet. If the landlord says that these units have no pet policy, so it is inconsistent with the RTA and it is null and void. So RTA strictly regulates the amount of money landlord can collect at the beginning of the tenancy, generally limiting to the rent deposit equal to the 1 month rent, and key money is prohibited. Landlord cannot demand for the key money. Now the rent regulation. The RTA controlled rent increases through an annual guideline, which is for 2025 it is 2.5%. He cannot increase above that. Landlord must provide at least 90 days written notice for the rent increase, and tenant can challenge rent increase that exceed the guidelines by applying to the Landlord and Tenant Board. In case the landlord increases more than 2.5%, then the tenant can go in the Landlord Tenant Board and just tell them that the landlord has increased above guideline to get the remedy or other possible solution from the Landlord Tenant Board. And there are some limited circumstances in which the landlord can increase above guideline, but this requires the LTB approval, Landlord Tenant Board approval, and are typically related to extraordinary increases in the municipality taxes, capital expenditures, or building security cost, in 3 conditions with the approval from the LTB, like extraordinary increase, capital expenditure, or building security cost. Rent can be increased during tenancy year if the landlord and tenant agrees for the provision of new services such as parking space. So another condition that landlord and tenant both agrees for the parking space or without percentage cap but related to the cost of the service. And the automatic rent increase can occur if the municipal realty taxes decline by more than 2.49% in a calendar year. Now the security of tenure. The RTA grants security of tenure, meaning tenants have the right to remain in their rental unit as long as they comply with the tenancy agreement and the law. Now the fixed term tenancies of 1 month or more automatically renews as a monthly tenancy upon expiry unless proper notice is given. Now the access to the rental unit. There are some specific procedures and the guidelines that the landlord have limited right to enter in the tenant rental unit. Generally, they must provide at least 24-hour written notice specifying the reason, date, time, and they can enter only between 8 a.m. and 8 p.m. for entry. With notice, 24-hour notice, and with reason, date, and between 8 a.m. to 9 p.m. for entry. And there are some exceptions, just in case of emergencies or if the tenant consent at the time of entry. Just for example, landlord knock at the door and he asked that I want to do something. If the landlord agrees and permit, then the landlord can enter. Otherwise, he cannot enter without permission. Now the landlord and tenant responsibilities. Landlords are responsible for maintaining their property in a good state of repair and fit for habitation, like complying with the health, safety, maintenance standard. And tenants are entitled to have reasonable enjoyment of their rental unit because they rent their property for their rest, for their enjoyment, but within certain limitations, not to bother other tenants. And tenants are generally also responsible for ordinary cleanliness, for repairing damage caused by their willful or negligent conduct. Now the termination of tenancy. So for the termination of tenancy, the RTA outlined the specific grounds and the procedure for both landlord and tenant to terminate the tenancy. Landlord can terminate tenancy for fault grounds such as non-payment of the rent with a typical 14 days notice, or the damage to the property, and no fault ground such as landlord own use or purchaser use that requires 60-day notice, and 1 month rent as a compensation. Just if the landlord says that I will be using for my own family member and you have to vacate that property, then they have to give at least 60-day notice and they will exempt 1 month rent for free because he is using for his own purposes, or renovation requiring the building permit. And the tenant must provide written notice to terminate in case the tenant is terminating with a notice period demanding the type of tenancy. That is generally 60 days for month-to-month tenancy. And if the tenant is facing domestic abuse, they have right to terminate their tenancy with only 28 days notice under specific conditions. unless tenant leave voluntarily after receiving the notice of termination. The landlord must apply to the Landlord and Tenant Board to obtain the eviction order. Assignment and subletting. Just in case the tenant want to add one more assignment in his tenancy, or giving another person for rent or for living in the same unit, he might be living for some time or other thing comes up, tenant may have that option to assign their entire lease or sublet their unit, but with the landlord consent, which cannot be unreasonably withheld. If the landlord doesn't permit, you are not allowed to do that thing. Now the Landlord and Tenant Board. So the Landlord and Tenant Board is an administrative tribunal that has exclusive jurisdiction to resolve dispute between landlords and tenant under RTA, Residential Tenancies Act. So this act operates under the principles of administrative law and the procedural fairness. Parties can bring an application to LTB regarding various issues, including the rent increases, repairs, eviction, or the breaches of RTA. The Landlord and Tenant Board, what it does, it conducts the hearing, which is generally open to the public. You can also listen those hearings going online with permission. While direct appeal of LTB decision to the courts are generally not permitted except on question of law for eviction order to the divisional court. So again, the Statutory Power Procedure Act, SPPA, generally applies to the LTB proceeding, and direct appeal again for the LTB decision of the court are generally not permitted except on question of law. When you are going for appeal, it should be only on question of law for eviction order, and it should be in the divisional court. So party can seek review also, review the decision of LTB order by LTB itself. If there is a serious error of law, if you think that there is some error, you can ask LTB for review hearing, and just error of law or fact, because if there is some other ground, they cannot review your application. LTB monetary orders from the LTB. So if the LTB order for the monetary compensation, it can be enforced through the small claim code, but there is a limit up to $35,000. If it is more than $35,000, it's beyond the LTB area. Then you have to go to other court, not LTB. The LTB can also orders for remedial actions such as rent abatement or requiring landlord to make repair. So administrative law contest in LTB. The LTB as an administrative tribunal exercises the delegated power granted by RTA. Its decision-making process are governed by the principle of procedural fairness and the natural justice, including the right to be heard and right to an impartial decision maker. And while the RTA limits direct appeal to the court, because LTB decisions can be subject to the judicial review by the divisional court on narrow ground, such as law or jurisdiction. If there is some thing regarding the error of law or jurisdiction, then the judicial review can be requested, but in divisional court, not in LTB. And standard of review in judicial review determines the level of deference court will give to the tribunal decisions. When we talk about the Ontario Human Rights Code, RT operate within the border framework that Ontario Human Rights Code, which prohibit discrimination housing based on protected ground such as race, sex, sexual orientation, disability, and landlord have to accommodate the tenant need related to these protected ground unless it would cause undue hardship. And landlord cannot deny on those grounds that some specific race, sex, color, that we don't give unit to such and such race, such and such orientation. And the landlord are also prohibited from taking reprisal against the tenant for exercising their rights under RTA, the Human Rights Code. And the tenant who believes they have experienced discrimination can file a complaint with the Human Rights Tribunal of Ontario. So there is something you have to concentrate. If it is regarding the issue for rent and other increase or pet or some other related landlord or tenant issue, they go to Landlord Tenant Board. But if it is a question of human right like race, sex, color or disability, then it's a human right. It should go to the Human Rights Tribunal of Ontario, and you know that it has a priority over Landlord Tenant Board. So in summary, the tenancy law in Ontario, governed by the RTA, set out the comprehensive framework for the rights and responsibility of landlord and tenant. And this legislation operates within the broader context of administrative law, as the Landlord Tenant Board function as an administrative tribunal resolving disputes. Furthermore, the RTA is subject to the principle of Ontario Human Rights Code, ensuring a fair and non-discriminatory housing landscape. And understanding these interconnected legal principles is crucial for navigating landlord-tenant relationship in Ontario. Just emphasizing that RTA is stated to have the purpose of protecting residential tenants from unlawful rent increase and eviction, and regulating residential rent, balancing the right and responsibilities of residential and landlord and tenants, and providing for dispute adjudication and informal dispute resolution. So there are some challenges also to the Landlord and Tenant Board. So direct appeal of Landlord and Tenant Board decision to the courts are generally not permitted, except for the appeal of eviction order to the divisional court, but only on question of law, which result in an automatic stay of the order if there is a question of law, otherwise not. And party can also seek a review of an LTB order by the LTB itself. LTB will review his own order if there is serious error of law or fact, and the Landlord or Tenant Board may also correct clerical error in the order. In case there is some error in the date or some error in the numbers, they can just remove those error and clear it. Now the enforcement. The order has been passed and the verdict has been disseminated. It is the enforcement now. The monetary orders from the LTB can be enforced by filing them with the small claim code. The LTB may also allow the tenant to deduct unpaid amount from the future rent. Eviction orders are enforced like a writ possession. Now the judicial review. While the direct appeals are limited, LTB decisions are subject to the judicial review by the divisional court on narrow grounds such as error of law or jurisdiction. And the court apply different standard of review to administrative decision. Generally, damages are not permitted as a court remedy in judicial review against the administrative body. Court might grant standing to a tribunal in judicial review proceeding when the tribunal made decision on the merit of the case. So the tenancy law. Tenancy law in context of Ontario Human Rights Code. The RTA operate within the larger framework of the Human Rights Code and supremacy of the code take priority over RTA in case of conflict. Prohibition of discrimination. And the code prohibit, when I'm talking about the code is Human Rights Code. And the code prohibit discrimination in housing based on protective ground, including race, ancestry, place of origin, color, ethnic origin, citizenship, creed, sex, sexual orientation, gender identity, gender expression, age, marital status, family status, disability, receipt of public assistance, or record of offences. And these are the discrimination or protected ground. The landlord must comply with the regulation made under the code when selecting the prospective tenant, and he cannot deny that somebody is disabled or somebody has a record of offense and such and such color. He cannot deny the tenancy on those grounds. Duty to accommodate. The landlord has the duty to accommodate tenant needs related to these protected ground unless it would cause undue hardship. This can include consideration for the services animal and the potentially emotional support animal. And in case some people are disabled and using the wheelchair, and the landlord has to provide the ramp to easily access for them. And prohibition of reprisal. Landlords are prohibited from taking reprisal against tenant for exercising their right under RTA or Human Rights Code. Human Rights Tribunal of Ontario, the tenant who believe that they experienced discrimination, they can file a complaint in Human Rights Tribunal Ontario. And HRTO can order remedies such as monetary compensation for injury of dignity, but it does not have the jurisdiction to order the cost. So finally, in conclusion, the tenancy law in Ontario, primarily defined by the Residential Tenancies Act, and establishes comprehensive set of ground and obligation for landlord and tenant. The enforcement and the interpretation of these acts are largely the responsibility of the Landlord and Tenant Board (LTB), an administrative tribunal operating within the principle of administrative law and subject to judicial oversight. So crucially, the RTI is situated within the border context of Ontario Human Rights Code, ensuring that the tenancy practices are fair and non-discriminatory. Understanding these interconnected legal framework is essential for navigating the landlord and tenant relationship in Ontario. So this board is basically to benefit both for landlord and tenant, and it's basically also providing the tenant rights that the landlord cannot go against those rights. Unnecessary increase in rent, asking key money, asking for basic facilities compensation. And you can also check with the Landlord and Tenant Board website how to file a complaint and what are the procedure. But these boards are made for both to resolve the dispute between landlord and tenant, and they act like court, but they are not actually court, and they are more relaxed, and the people feel very convenient and talk anything related to those matters. And this is for all regarding landlord tenant board. I hope you understand those terms, and thank you very much. Stay blessed.